Thanks, Margot, and thanks, Judge Mitchell. By way of background, the Honorable Reverend Everett Mitchell attended Morehouse College, where he earned undergraduate degrees in mathematics and religion. He went on to earn Master of Divinity and Master of Theology degrees from Princeton Theological Seminary and a JD from the University of Wisconsin-Madison. In 2016, he was elected to the Dane County Circuit Court at the age of 39. He is now the presiding judge in the Juvenile Division and also oversees Dane County's high-risk drug court program. Judge Mitchell is an adjunct professor for the University of Wisconsin-Madison Law School, teaching courses on race, racism, and the law, as well as foundational principles of the juvenile justice system. Judge Mitchell is a fierce advocate for education and equity. His approach to dismantling the pipeline that he talks about today has been documented in the Wisconsin Public Television series, Not Enough Apologies, Trauma Stories. He believes passionately in the endless potential of children and communities to transform their trauma stories and wants to make sure that the court system does not contribute to the ongoing traumatic narrative that many children and families experience. During his tenure on the bench, Judge Mitchell has worked with colleagues to change courtroom policies to reflect trauma-informed practices, such as removing restraints and handcuffs on youth during hearings. He joined several judges in successfully petitioning the Wisconsin Supreme Court to support changing the presumption to ensure that children in Wisconsin can attend their court hearings without restraints and handcuffs. That was an effort that Wisconsin Justice Initiative was proud to support. Additionally, Judge Mitchell worked with the Madison Metropolitan School District, the second largest district in the state, to create an Office of Youth Engagement that provides a bridge for youth involved in the criminal justice system to educational programming. Judge Mitchell tries to connect the community with incarcerated youth and adults. Through his support, members of the Black Law Students Association regularly visit the local detention center so that law students can eat lunch with and engage youth in the detention center. Judge Mitchell is adamant that the first time people see him should not be when they appear before him in court. To that end, he has visited over 30 schools in Dane County to talk with children about the juvenile justice system. Judge Mitchell has also lectured or spoken at colleges and universities, national conferences, community events, corporate events, professional development workshops, and in front of many other diverse audiences. Since 2011, Judge Mitchell has served as senior pastor of Christ the Solid Rock Baptist Church in Madison, Wisconsin. His resolve to pursue love, service, justice, and equity led him to identify his congregation as a church that is open and affirming to those in the LGBTQIA community, and it is the only predominantly Black church to do so in Dane County. Judge Mitchell also recently led his congregation into a formal alliance with a majority white congregation so that both congregations can be intentional about dismantling racial barriers. Judge Mitchell is most proud of being honored with the 2017 City of Madison and Dane County Reverend Dr. Martin Luther King Jr. Humanitarian Award. So thank you, Judge Mitchell, and you can go ahead with your remarks.
All right. Thank you so much, everyone. I appreciate this invitation and opportunity to come and talk about something that I'm very passionate about. This is kids and juvenile justice, and more specifically, the work that as I see it in juvenile justice and the things that we've tried to do here in Dane County and lead throughout the state to make sure that our court systems are both fair and equitable, of which when I became a judge, I did not see a lot of fairness and I didn't see a lot of equity and I didn't see the courts administering a lot of justice. We dealt out sentences, but I don't think they were always just. So my remarks today really are about how I've approached the bench and more importantly, how I approach juvenile justice. So I prepared a PowerPoint that I'm gonna share with you today as we kind of go through this together. And I'll try to make my remarks as clean and as succinct as possible so I can leave enough time if there are any questions about this process and philosophy. I always want to start off with, I know that a lot of people think that judges We find, bookends in statute and case law, and that is the only thing that we use. But for the most part, there's a lot of discretion that, judges are given to make decisions. And so one of the things that I always like to remind people is that there are things that we have to have that ground us in our philosophy as we approach cases. And there are a couple of things that ground me in my philosophy. One is this quote by Frederick Douglass, and the idea that it's easier to build strong children than to prepare broken men. It grounds me in the idea that if we're going to really be about justice and fixing the system, then we can't wait till people get in the adult system and think that we're going to radically alter the process by which people get there. We have to start sooner with some intentionality about how we approach every case and those we see. It is also this idea from Brian Stevenson that we've submitted to the harsh instinct to crush those among us whose brokenness is most visible. But simply punishing the broken and walking away from them or hiding them from sight only ensures that they remain broken, and we do too. I think this philosophy really touched me when I heard Attorney Stevenson come to UW, and I had a chance to be with him as he did his presentation. And it was this quote that he kept reiterating to the audience, this idea that hiding people just because we don't want to deal with their trauma or their pain or the things they've been through only ensures that our entire system of humanity remains broken. And you can see it even more so with children. Because we were doing a great job of hiding them in RCCs, hiding them in Lincoln Hills, Copper Lake, and realizing that they were just staying broken in those places. And as a result, broken families, broken systems, broken generations, all of that stuff just kept broken because we weren't able to see them for what they had been through. One of the things I like to talk about is this idea from Oprah, and it's this quote by Toni Morrison when she asked a question: does your face light up when the kid walks in the room? So when we think about bigger things of systemic injustice, a part of small ways in which we can facilitate justice is just this little quote real quick. Let me just play just a snippet of it for you.
If you were to ask me in the early 90s, what is the big lesson you've learned from this show? I would have said that the common denominator in the human experience is that everybody just wants to be appreciated or validated. That got clarified in such a way that the hairs on my head rose when I heard Toni Morrison, who was on the show for The Bluest Eye, one of my favorite books of all time. I'd chosen her for book club selection yet again. And she said these words.
It's interesting to see when a kid walks in the room, your child or anybody else's child, does your face light up? And that's what they're looking for. When my children used to walk in the room when they were little, I looked at them to see if they had buckled their trousers, or if their hair was combed, or if their socks were up. And so you think your affection and your deep love is on display because you're caring for them. It's not. When they see you, they see the critical face. What's wrong now? But then if you let as I tried from then on, to let your face speak what's in your heart, because when they walked in the room, I was glad to see them. It's just as small as that, you see.
That is what.
So that's one of my go-to ideas when we think about systemic, is this notion of what does our face say when we think about the young people? Because I think when they come into the courtroom or they come into any process, all of them are looking for that validation that you see them, that they're not invisible. And that has been a part of what I put into my practice on the bench. When I became a judge, one of the things that, we were ideologically, people talk about the school to prison pipeline, but it was became very clear to me very quickly that that's not the pipeline that's operating in Wisconsin, that's dominating and sending us into this, all the disparities around adult incarceration in our communities. Rather, I saw it as the child welfare to juvenile justice to the adult prison pipeline, because we were passing traumatized children from one system to the next and not giving them the resources or connectivity to be successful as they pass through our systems. And so the documentary, Not Enough Apologies, Trauma Stories, came out of me asking, how do we give a picture to the community, to our state, about the state in which we are sending these children through these various systems and not getting them the help they need, and then ending up surprised that they're ending up in the adult criminal justice system. But the reality is that there were so many different things that were not coordinated, that were not put together, that were not thought out. And it was surprising that people seemed unaware that these things were happening, or aware that this was going to be the inevitable outcome, would be the young people would ultimately end up in the adult system. And they're going to end up in the adult system without the emotional or educational tools that they need to mitigate and move out of that system and be successful in the future. And so all of these different ways in which I put this together was just so I could have a system to explain what I was saying and a way to describe it, and how it was operating in this community. So then we started talking about trauma. So trauma became a language, right? When I thought about how do we bring trauma and conversations into it, where it's not just used as, where they just not accepting responsibility, but that they talk about the legitimacy of trauma. And this book, this book was one of those instrumental texts, The Body Keeps the Score, mainly because he talks about how, in many ways, those who experience post-traumatic stress disorder in war is similar to what children experience when they experience the trauma of their lives. And, we have a lot of different ways in which we respect trauma of vets, and rightly so, but we're not always willing to extend that same grace to young people who are experiencing the same ongoing trauma events in their life, and then the implications of how that works out. So it's this idea that trauma can be passed down, and it's passed down from one generation to the next. It's not stopped. And if we don't stop it, it will continue to do its damage. But what he also talked about is the idea that imprints from the past can be transformed by having physical experiences that did directly contradict that helplessness. So if we can create a system by which they are directly having moments where they contradict it, you can help the helplessness and the rage and the collapse as part of that trauma. But we have to be intentional about creating those direct contradiction of experiences for them so that they can be transformed and that imprint can be transformed. So a lot of the things that we deal with that gets on the news is always about, young people stealing cars. And that's a major thing that happens in Dane. I'm sure it happens in other parts of our state too as well. And so it gets a lot of headlines with that. So I always go back to what is our legislative intent. And so some of the legislative intent is always to protect citizens, to hold each juvenile offender directly accountable for his or her acts, to think about individualized assessments so that we can prevent further delinquent behavior and develop competencies so that they can live productive and responsible lives. That's part of the intent of the legislative code, to look at the individualized ways in which we look at young people and their lives. We want to make sure there's due process, because due process and fair hearings in which their constitution and other legal rights are recognized and enforced. I don't think people always attach due process to children. We think about due process, but when you think about the youngest of people, how people understand the court system, a lot of times is how they understand due process when they're young. And if they don't have a good experience at a young age and trust that it's fair, then they're going to grow up thinking that the court system is inevitably unfair. And then we're supposed to divert juveniles away from the system through early intervention. We're supposed to be trying to get them away from the system and allow for them to be protected and the public to be protected. We're supposed to respond to the individual needs for care and treatment. And we also supposed to make sure that courts utilize the most effective options to do so. And then we're supposed to ensure that the voice of our victims are also included in that process. So those are the 7 intents that we focus on. And even in Dane County, we still see a lot of juvenile disparities, even up until 2019, right before the pandemic. We start seeing a lot of disparities. And, right before I took over for one of my colleagues as a presiding judge, one of the things that I targeted quickly was minimizing the racial disparities in Dane County because they were so glaring. And we needed to really get ahead of that and try to figure out what are we missing? What have we done? What can we do? And what can we better at accomplishing in our community? And so the work that I'll be talking about in a second is really comes out of that sense of what can we do better and how can we do it better so that our systems can work to increase the success of our young people and not continue the legacy of disparities in our county. So one of the things that I pointed out, I'm a firm believer in education. So I don't think that you can, really expect people to change the dynamics of their life if they don't have the education to do so. It's just not even reasonable. It's not possible. But I realized that a lot of our young people who had IEPs, individualized education programs, were also placed in shortened school days. And so, one of my young people who tried to go to school, she was not being allowed to go in schools, and they were literally undereducating kids and only sending them to school for an hour to hour and a half a day. And they were not getting the full 8 hours that most kids go to. And so this bulletin in 2014 by the Department of Public Instruction was sent out, but nobody was following it. They were choosing to interpret it all day. So they were using showing school days to manage behavior. They were making students earn back their privileges to go back to school during a full day, all of which were in violation, and then using attendance to make sure that they weren't allowed to go in. And all of these things were used against young people so that they couldn't put them into a full shortened school day for them. And so obviously fairness comes into this, because they were asking me to put kids in jail because they weren't attending school. Well, I'm like, well, they can't, how am I supposed to punish them for attending school when they're not allowed to be in school? And so that's why we had to, I threatened to sue on behalf of my kids, Madison School District, because I could not find another way to get people's attention that this is wrong and highlight why we had done this. And so we found out over some conversations with the school district that, this practice had been given to every individual school, and they had been doing it for over 20 years, putting young people with IEPs who were court ordered in shortened school days. I want you to think about 20 years. And in that 20 years, that pipeline got increasingly strong because there was no connection between their education and their special education needs at that time. And they were using court systems to help punish these kids and further incarcerate them because of the orders that were put in place during that time. You read about the restraints. That was very important. I'll just say that it looked good on paper to talk about the use of restraints, but I can tell you it took a long time for us to have that buy-in from multiple partners here in Dane County. And once we did, it really did give people a sense that maybe we had been doing things in a way that was not consistent with what was in the best interest of these children. And the push toward making sure that the second largest county that deals with juveniles to be able to present that to the Supreme Court only meant that we had evidence that court systems could do this and they could do it safely. And we had been doing it in Dane County. By the time I got up before the Supreme Court and, advocated for that petition, we had no hearings that required an additional safety concern in our county in over 5 years. So it said that we could do this, but we had been doing it for years indiscriminately without any support that this was a viable way to treat young people and their cases. We realized that we had other things that was important. We didn't have limited access to cultural counseling. We didn't have culturally based counseling for people. Contracts were limited. We didn't have a residential care center in our communities that were close. We had state sanctions, denials of opportunities to give people help. We had no group home options in our community. So it was no surprise to me that we had, these issues coming up because we had no place to give kids the treatment that they need. And if we were moving them away from their families and their communities, so they weren't getting the substance of hope that we wanted them to receive. We started paying attention to the unsubstantiated cases. So juveniles will come into court and we'd be saying, okay, they have these many charges, but how many times have they been contacted by CPS? In one juvenile's case, they had over 37 CPS referrals related to one child, 37. And so that means that there were incidences where the child welfare system may or may not even have investigated the abuse that was happening to this child. And as a result of that, they continue to live in a situation that was consistently abusive over time. Probably the more recent issue that has come up is this idea of what are we going to do with Lincoln Hills? I will say that as a legal issue, this is probably causing the most tension among some of our juvenile judges, is because there's so much disagreement as to whether or not courts have the capacity to actually send these kids to DOC supervision if there's a necessary need for that kind of accountability. The old law gave us clear power to do so. So we may place the juvenile in a correction facility. Well, the new law, which was, they intended to close Lincoln Hills, says that we can only place a juvenile under the supervision of the county department in a secured residential care center for children and youth as identified by the county department. So it removed the fact that you could put them in a correction facility because they were anticipating that these CERCs these secured residential care places would be built so that we would have that as an alternative to placing children up under to Lincoln Hills or to the Department of Correction or to a correctional facility. That's the key. It's a juvenile correctional facility. At one time, Milwaukee, Dane, Brown, and Racine were planning these new facilities, but Racine alone was the one moving forward with these plans, and no such facility exists right now. And on July 1st of last year, the daily rate counties paid for each youth held at Lincoln Hills, Copper Lake, and Mendota doubled from $615 per day to over $1,154 a day, which is about close to $421,000 for a youth to be incarcerated at Lincoln Hills right now. And so even in Milwaukee, the Journal Central did this report about Lincoln Hills Juvenile Prison was set to close in July 23rd. So why are judges still sending children there? And I think the Milwaukee judges are, do not believe that the law and ways in which they want us to send kids is legal. Different people have interpreted the memo that came from the Department of Corrections as a change of placement, and that is what we should be using to, place young people in the Department of Corrections. But the idea is that, for judges, we're not supposed to go off of legal memos, especially when they're drafted by the Department of Corrections. They're not statute related. They're not guidance from the Supreme Court. It is simply memos from or legal interpretations based from the Department of Corrections, and that is not always the standard that we should be using to better inform how we should engage in our statutory and constitutional practice as being judges. But we still are struggling with that, still trying to get the legislature to adopt some rule or somebody to give us a stopgap on how we should keep our community safe, as well as meet the specific needs of young people when either the DOC, they can't go there, nor were the places where we were supposed to be able to send them or built or exist or have staff to be able to support that. But I don't always want to think, Angie, with a note that it's all doom and gloom, because it's not. I think there are moments when I see so much beauty and so much life and joy in the relationships and opportunities that, I bring into the court system to give exposure to our young people. I'm a firm believer on exposure, experience, and education. I think if you have the 3 E's, the kids are more likely to be successful in their overall trajectory of their future. So one of the opportunities was I partnered with this nonprofit called Above the Clouds, which was a woman who was a former pilot at United Airlines, and she wanted to expose youth to be able to learn the beauty and power of aviation. So one of my court-ordered kids, she wanted to, she was in the cars and all this other stuff. And I said, how about we expose you to something different? How about we give you an exposure to an experience? And so rather than still in cars, you can talk about, flying above the clouds so that you can understand your future and your destiny. It doesn't need to be rooted in that. And man, the day that she got up in that plane, you're going to see her being so nervous, but she earned her flight jacket and her glasses, and she was so successful. So, I believe in that exposure, and the more I can give these kids that exposure, I think the better overall outcomes they will receive. I like to bring kids to my chamber and let them be able to have conversations about justice and fairness, even when they think that it's not possible. Just by sitting in this space, they get a sense that they can be heard and that they can contribute to a society and transform whatever situations that come into their own space. I like to bring them into courts so that, like I said, the first time they see me is not when they have a case. But right before COVID, I'd have, cohorts of kids coming through, at least once a week, just to talk to them about justice, so they can sit behind the bench, so they can bang. They love to bang this gavel. They just love to bang it. I think everybody thinks that this is what court is banging that gavel and telling people, order in the court. But, I let them bang it just so they can get that experience and enjoy being in the space together. Like you said during the introduction, I partnered with the MMSD, Madison Metropolitan School District, and we work to open an office called the Office of Youth Engagement, which is really intentionally trying to connect our court-ordered kids with education. Because the moment that they were removed from home and placed in these different places, we realized that there was really no connection between their placement and when they needed to come back to school. Nobody was monitoring that. Nobody was making sure that they were, doing the consistent credits that they needed to take in these other placements so that they could easily transfer back into the school. And so we had to create that office. And this is probably one of the bigger offices now that the current superintendent has used to support, to ensure that kids do not get lost in the shuffle between our two systems. So we needed a better relationship, a stronger relationship, so that our systems can make sure we kept the connection with the children. We work with the MMSD and DPI to revamp the process of shortened school days. So rather than giving that discretion to every school building, it has to come through central office, and they have to approve it before they guarantee it. Obviously, start putting more frequent reviews to ensure that children are actually receiving mental health services that they need in a timely fashion. Working to make sure that the systems are not stopping the young people, but that they're actually getting their services. And then collecting Black and Brown youth with culture relevant services that address their trauma and other needs. I've done stuff like spend Thanksgiving and Christmas Day with juveniles in detention, because that's the loneliest time for kids who can't get out to be with their families. And then lastly, I apologize to young people who have experienced more trauma as a result of being hurt multiple times by our system. And to have a judge say, I'm sorry, it's something that I think many of these young people never anticipate and never think will happen. So by me giving them that sense of apology, it may be the first time that some of them ever heard an adult say, I'm sorry. But I want them to understand that our intent is to be better, and that we will be better. And it's not just an apology just for the past and not going to be paying attention to the future, but it's a commitment that when I say I'm sorry, that I would also commit myself to doing better and ensuring that our system is better as well. So like, I love to just do different things in court. So sometimes, I may pick up a baby that was crying. This baby was crying during an adoption hearing one time, and the mother couldn't seem to get him to calm down. I said, just give me this baby. And as soon as I got him, we put him on my chest, he went to sleep. And that was a special. I just did the rest of the adoption hearing from my bench while I was holding the baby. Like I said, I bring kids all the time, young kids, different programs. And I have this thing where if it's a group of kids, we do an exercise in the courtroom where I pick some kid who's probably the most oppositional kid in the group to come in and be the judge. And in this case, it was one young woman. She was so oppositional that day. So I let her come in and participate that day, and, and gave some fact scenarios, some fact patterns for all of them to look at different stuff and just see how they would respond and how they would judge. And I can tell you, kids are way harsher in their judgment than I ever am. So they were that. All right. Again, bringing kids in. I go out to the community all the time. I'm everywhere with these young people, always putting them on road and giving them opportunity to see themselves, not as a rapper or a sports player, but just also as a young person who could be a judge one day too, because that's important to me. I like to speak to groups of young men so that they can see that, prison need not be your path towards your future. I don't know how that narrative had gotten stuck in our community, but it has. And I'm trying my best to rectify and give them different visions of what's possible. This young woman stole my heart because one day she came, I went to go visit the high school, and she was there, and she was just, she was tuned out, didn't want to hear nothing. So I gave her some stories about injunctions and my injunction day, and, they started laughing. And by the end of the class, she leaned over, she said, I think I might want to be a judge. So immediately I jumped into action. I told the teacher, I said, listen, I want this whole class to come down to the courthouse. I'll pay for pizzas and drinks, and, just bring the whole class. And so 2 weeks later, on a Friday, she brought the whole class. They hung out with me. We talked about life. We talked about things. And at the end of it, I said, well, why don't you come and, try on this role? Because, we don't have an African-American woman yet on the bench. And maybe that could be something we could see it in your mind that you want to try one day. And she was so excited. She was so excited. And it turned all those frowns and apathetic attitude I saw before. She was shining by the time we finished our time together. And so I'll end with this. So I always start with this idea that I'm not your judge, I'm your reflection. Because I think a lot of kids, they see me enter and they see a black robe, they assume certain things. Not only kids, adults who assume the same things too, that you must have come from like a certain family, you must come from a certain background for you to achieve all things you've achieved as a judge. And I'll tell them that's not the case. That I was just one of those traumatized kids too, that, experienced trauma and abuse and years of it, struggle with, reading and literacy for years, really fighting over the years to try to, push toward education and try to push toward success. And so when I see these young people, I always say to them that, I'm not your judge. I'm a reflection of what you can achieve. You can achieve greatness, and you can create status and strength in your life, that the trauma narrative need not be the final chapter in your life, that you can write new chapters, and those new chapters can be written. You may not be able to change the past, but you have everything within your strength and capacity to change your future. Now, is that written? How you do that? Is that written in statute? Is that written in how you do it in case law? No, but it's rooted in the sense that systemic injustice is real because it's made up of people, and systems are people are the ones who dictate these systems. And if systems are messed up or made, racialized or homophobic or sexist, then it's up to those same people to create a system that's the opposite of that. And so that's what I'm doing as a judge, to use my power, not just so I can go golfing on Fridays, but to use my time as a judge and influence to do exactly what I believe statute asks for us to do, which is to use our influence so that people have a sense of the fairness and respect for the court system, and more specifically for our judicial officers. And that's what I've chosen to use that Black robe for, to honor the commitment of what many before me have done, and many after me will continue to do, if we choose to focus on what fairness and justice should be and must be in our state. So I'll stop there. And, if you have any questions or thoughts, I'd be free and excited to be able to answer them today.
You talked earlier about a lack of, or at least lower levels of due process in the juvenile system. Now, I'm unfamiliar with that because I only practice in the adult system. What differences did you see in the juvenile system when it comes to due process versus the adult system?
Probably the biggest thing is that, it seemed like juveniles are treated as guilty, and then they have to prove that they're innocent. Right? There's a lot of, Miranda rights that you're given in adult, right? People, oh no, don't do that to me now. There are a lot of people stressed by Miranda rights, and those Miranda rights you have to focus on. In the juvenile system, nobody's telling the kid, you have a right to remain silent. Yeah, they're not reading those Miranda rights to these kids. They just start talking to them, and the kids are never advised that these words will be used against them. So they talking to the social worker, and those words are used against them. They're talking to police, they use against them. Even statements that they have made inside of schools and other places are the statements that are used against them when they don't, when the state really is supposed to prove their case against them. So there's a lot of processes that are extended to adults that are not necessarily extended to children. And so because of that, I think, we don't see as many trials, and we don't see as many, kind of conflict moments within the system, because these young people basically give away all of the facts before there's an opportunity for them to understand how these words impact them. Most of them don't even see legal counsel until after the case is already charged. And so because of that, they're talking to people the whole time and not realizing this process. So that's probably one of the biggest pieces that I've seen. And I don't always think that the ways in which we work with the young people highlights the need for them to understand that they do have rights. And one of their basic rights could be a right to remain silent in these different spaces, because those statements will be used against them. Yes, Judge.
Hi, Judge Mitchell. So I am the second newest judge in Milwaukee County, and I'm at our children's court. And so I became aware of you because I have read some articles about all the great work that you do, and I know that you've been called the advocate judge. And one of the things I found on the campaign trail last year was that there are a lot of people who say that it's not a judge's role to be an advocate, or to be out there in the communities, asking for certain things, or aligned with certain causes. And I'm wondering how you would respond to that.
I would say that as a judge, if you pay attention to our Supreme Court rules related to what a judge is supposed to do, one of the things we're supposed to do is represent our office with a level of dignity and fairness. We're supposed to ensure that the court system is fair. How do we do that? It doesn't tell us how we do that, but we have a responsibility to do that. And if we're not making the court system fair, then that means that we are participating in the delegitimacy of our court systems, which, in my opinion, we cannot afford. We can ill afford for people to believe that there is no fairness in our court system. We have to be the ones who are saying to not only our court system partners, but our community partners, that this is unacceptable. Because what they will do is use your court and use your authority to then lock kids up or to punish other people at the same time. So I think that's why there's been, in my mind, there has been a stark divide between one generation that may have believed that that's not our role, and the new generation that says, like, I'm not going to do that. I'm not going to participate in that. And I would have too many hearings where the request is, let's lock these kids up because they didn't do this. Well, let's think about that. Why didn't they do that? And then, when the kids start speaking up, that's when we realized like there were some issues, or the fact that, I would have cases where mothers could not get their children back because there weren't mental health services that were part of our disposition for them to be able to get in their conditions of return for them to be able to get their children back. And we were signing contracts with providers that would tell us that we'll get them in about 3 to 4 months. Well, that's not going to work when we're dealing with real life children and families, right? So I tell people, the press loves to, spin me to meet what I think the press loves to spin me to meet, but I'm not an advocate judge. I'm a judge that should be advocate that all judges should be doing to make sure that our court system is respected and fair and just, right? And there's no other, when you put that black robe on, that's what you should be. And to not be that in many ways, minimizes who we are and the brand of our justice system that we represent. So when you roll out into the community, whether it's Milwaukee or not, you don't need to be silent. Nobody asks you to be silent. Nobody says that's the case. That just people may not feel comfortable with it. But the lack of our feeling comfortable should not stop us from being able to have that sense where we go in and say, all right, this is our role. This is not what we should be doing. So like the last example, I didn't use this one, but when I became a baby judge, kind of like you are in many ways, they put me on a committee for CCAP. That was the first committee. They were like, don't nobody want this job. Judge Mitchell, you got to take it. I'm like, man, I don't even want to do that. So they send me to these CCAP meetings, right? I'm sitting in a meeting with CCAP. And the first motion that's on my first time sitting on CCAP was, and Attorney Ramos was on there with me. He was there with me when I did that. And I'm sitting there and they were like, what should we do with CCAP? Should CCAP just remain and all these things sit on CCAP forever, 30, 40 years? And I sat back and I said, no. I'm looking at the prosecutors, I'm looking at defense attorneys, I'm saying, no. I said, if a case is dismissed or a person is found not guilty, that case should immediately come off CCAP because they are presumed innocent. So if they are dismissed and I'm looking around the room, I'm like, who else going to support me? And I think people were just quiet. They were just silent, right? No, they're silent. And so I kept pushing the issue. I kept coming back. I think they were thinking I should go to court and not be in that meeting anymore. But I kept coming back saying the same thing over and over again. We shouldn't do this. And we were getting ready to do that final vote. And I remember Representative Voss walked in the room that day. He walked in, sat across the table, and he said, I agree with the judge. I never thought I'd ever hear that word come out of his mouth, but he said, I agree with the judge. Because he had an experience with a staff in his case that had said the same thing. And so in that moment of advocacy, we went from having a case sitting on CCAP for 30 to 40 years for innocent people, right? Innocent people. And it went down to either getting removed quickly or at least minimum to about 6 months to a year, depending on the case. Now, when we did a study, because I said, well, let's pay attention to the data. We realized that over 200,000 Wisconsinites had a something sitting on CCAP that it was either dismissed or on the prosecutor's motions, or they were found not guilty, and it was still sitting on CCAP. So when we did that, was I an advocate judge? No, I was being a judge who was standing up for what our system should be, and I think supports, and I think the outcomes for Wisconsinites is going to be better in the long term because I didn't stay silent in that moment when I had an opportunity to use my voice as a judge, and more importantly, as a human being to, change a system that had been hurting so many different types of people. They ain't gonna never know who it was, but when they come off CCAP and they can go get that job or get their housing or have their innocence restored, then they understand why judges using their voice are important. Does that make sense? Mr. Gremlin.
Hi, Judge. How are you doing?
Good.
You described the importance of judges in the system addressing trauma when it's identified, intergenerational trauma, a difficult chore. Can you describe successes that you've seen in your time in court where trauma has been addressed and where it's that effort has really produced rewards?
Oh man, I can't tell you so many beautiful stories. of seeing families getting in and getting their trauma addressed. When we partnered with, we worked hard to partner with a new startup organization that was providing culturally based mental health services for families. And the goal was to use them to go inside the homes to work with the families, to address the trauma, to address the communication. It was Anesis Home Care. And literally, Anesis coming into people's homes allowed us to go toward reunification almost months quicker, because they were able to have those culturally relevant services being placed in home and working with those families in a way that they felt comfortable and not threatened by the system. So I've had grandmothers, mothers, fathers, children reunified, and they have not come back into the system at all. And so I see that among our families. I see that in our CHIPS cases, as well as my JV young people who are able to talk about what they have been through in a way that leads them away from the criminal justice system. I will say that so the outcomes continually and consistently show that when we address the trauma, especially early on in these cases, then we see a different outcome. And I think what we have changed in Dane County that I think is most important is the practice of when we give children services, because normally our statute, especially chapter 48, when we remove a child from home, we weren't giving children services. We were focused on the parent, but we weren't focusing on the kid. So we never even assigned a counselor to the children when we removed them from home. So I started to say, no, in our orders, we need to make sure that the services that we're asking to be provided also include services for the children, to ensure that they are also getting, mental health prioritization in the system, and they can process this removed from home. They can process what is happening with their families, the trauma that they have had. We can't wait till they get into a JV system to then start ordering that kind of treatment. We need to make sure that, yes, we need to focus on the parent or guardian, whatever brought them here, but we also need to empower the young person with the tools necessary that they need in order to make that shift as well. It's been beautiful. It's been beautiful, man, to just see them come back together. We ain't talking about, 2-3 years out of home. We talking about 6 to 9 months out of home, and they're able to come back because, we put the emphasis on the trauma. And the last thing is that now we have a shared language among not just the court system. It's good to have my other colleagues who also talk about it, but our entire system now is using the similar language. So even when children come to court, it's also the same for their social worker, for the intake worker. They're all thinking and looking for the same things together. And I think that coordinated effort around that trauma then gives us the power to be able to look at them and look at the ways in which the trauma then can be addressed in the multifaceted dimensions that the children and families impact our court system.
Great, thank you.
Yes, sir.
Raphael?
Judge Mitchell, thank you for coming and talking to us. I've been really excited to hear you speak about the coordinated partnerships that you've developed. I come from a housing practice, and one of the things that's discussed a lot in our area is the development of a housing court that kind of incorporates and integrates different services with the court and tries to do these different things. And, we've seen lots of different sorts of initiatives that create these partnerships, but they're really just referrals. That's one group to another. And I would love to hear your thoughts on what techniques you've adopted, what strategies you've seen as being successful in terms of creating true partnerships that actually achieve a goal to actually improve the outcomes for the people in that court, as opposed to simple referral systems, but like real, true, successful partnerships.
Yeah, so probably the biggest one that I think is the biggest an enduring partnership is the Office of Youth Engagement. I've worked on many different partnerships, but the Office of Youth Engagement is probably my, most important. And I try to anchor it that it's not necessarily a referral, but it really is I call it a net. So referrals are kind of linking, but nets don't let nobody fall, right? And so that's how I envision it. And so the linking together with the school district ensures that the partnership is there to ensure that we do not let any children kind of fall throughout that process, and families don't do that. So one of the strategy is always understanding what their mission is and understanding what my mission is, and our mission here is the court, and then see if there's some alignment in what those directives look like. right? It's easy sometimes for children because obviously that is their mandate to make sure that children are educated. It's also our mandate to ensure that, young people are whole. We're diverting them from the system and, all those different things that the statute requires for us to do. And then try to then strategically figure out, well, how do we make this happen? And that is the magic of creativity. All right, how do we make this happen in a way that is not just kind of like a referral, paternalistic, or we just saying something, but how do we make this really happen? And I think the nuts and bolts of how to create that is where you need the creative minds to come around the table, that you pull different voices in and say, okay, this is the goal we want. How do we get there? My goal, obviously, was that I didn't want to have young people spending 3 or 4 months out of school because we don't know what credits they had from other places. And the school district didn't want to do that because they were mandated to be able to provide education to these kids. When we sat down and brought kids to the table, brought educators to the table, superintendent, brought some staff, social workers, we were able to create a partnership that really was rooted in the very successes that all of us wanted to see. And once that happened, they were able to use our statements to the school board to highlight why this was important. And the school board has picked it up over the last 4 years, and they've continued their partnership. And so, is it going to be tweaks every now and then? We have to tweak it to make sure. Yes. But having that commitment and relationship across the spectrum of people has really allowed for that program to survive, and it continues to thrive today. So I'm fingers crossed that it will continue to thrive. But our young people are being served in ways that they weren't being served several years ago. And they can get into school quicker. And now the office has evolved. It used to just have 2 staff people. Now it has 8. And that 8 staff people are all in these school districts advocating and trying to be on the front line of stopping some of the violence that we're seeing in our communities, as well as working with those families to make sure that those young people are getting the services that they need so they're not out stealing cars, and that their educational outcomes are going to be successful.
That's wonderful. Thank you, Judge.
If there's no more questions, I want to thank Judge Mitchell for his time and for his passion and his willingness to spend the time with us today, just expressing that. I want to let you know about our next event. So in May, we are not going to have a salon like this over the lunch hour by Zoom. Instead, we're doing a big in-person event on May 19th with Mark Joseph Stern. He's a reporter for Slate, and he covers the Supreme Court. The title of his talk is Can Democracy Survive the Supreme Court? And he'll have plenty to talk about. So we're flying him in from Washington, D.C. It's a 2-hour event on a Thursday evening, and we'd love to see you there. Sponsorships for that are available. I'm going to stick the registration for that in the chat, but you'll also see it in our newsletters and on our website. And we'll get the word out. We are having some postcards sent out, so you'll be getting the information on that. But if you have any questions about that, please do just email me at margo@wjiinc.org. So until we see you again, I want to thank you for attending, and hopefully as things clear out with the pandemic, we'll be able to see you in person in May. Again, thank you so much to Judge Mitchell, and have a nice afternoon, everyone.
Thank you, everybody.